Thank you very much for attending this meeting. My name is Fernando Rosales. I am the program coordinator of the Climate Change and Sustainable Development at South Center. First of all, I would like to thank the IISD for the organization of this Trade and Sustainability Hub, where we are contributing with this session. I also would like to welcome all the people attending to this virtual meeting. Today, we have a high-level set of panelists to discuss the issue of investment facilitation for development, identifying key policy issues for facilitating responsible, inclusive, and resilient investment. The CVs of our today's panelists are on the website, so I am just move direct to the presentations, starting with the introductory remarks of Professor Carlos Correa, Executive Director of the South Center. Professor Correa, you have the floor.
I don't think he's here yet, so if you could go on to the next speaker and we can go back to him. Perfect.
So our next speaker is Professor Surya Dev. He is the chairperson of the United Nations Working Group on the issue of human rights and transnational corporations and other business enterprises. So, Professor Surya, you have the floor.
Thank you very much, Fernando, and I also like to thank at the outset South Center for organizing this important event and giving us the opportunity to participate in this conversation. Of course, the ministerial conference has been postponed, but I think this issue remains quite relevant. And I very much hope that the discussion that takes place today will inform the position of different states and other stakeholders going forward. Now, this issue of investment facilitation, in my view, is not a new one. It has been discussed at the WTO on several occasions. So this is not for the first time. At the same time, if we look at the wider context, the issue of investment facilitation also has a colonial history. We can go back centuries and centuries and look at how investment and trade was used by certain powers to colonize the global south, many countries in the global south. Now, in the post-colonial world, and of course, we're talking about a globalized world in a free market economy, what lessons can we learn not only from the past, but also from the International Investment Agreement? I think those issues are definitely going to be quite relevant. So my remarks today will be based on what lessons should we learn from the international investment regime, so that when we are discussing those issues of investment facilitation in the WTO setting, we do not repeat the same mistakes. We do not want to create another broken system, a system which does not work for the benefit of everyone, a system which creates power imbalances, a system which leaves millions of people behind. So we don't want to create another system of that nature in the WTO. In my view, there are three major concerns that we have under the international investment regime that we have outside WTO. One is about imbalance between the rights and obligations of investors. If we go back in the 1970s onwards, the United Nations has been trying to discuss the obligations as well as the rights of investors. Till now, 50 years on, we have not been able to negotiate and agree upon legally binding obligations of investors. A process is going on before the Human Rights Council to negotiate a legally binding instrument. That process is 7 years old now. And we are still far from reaching a consensus to impose obligations on these investors and businesses. At the same time, in parallel, if you look at 1990s onwards, these investors have gained significant rights to protect their economic interest through bilateral investment agreements and regional investment agreements. And this is the story of imbalance. And this story of imbalance is also reflected in the vaccine crisis or vaccine inequity that the world is facing now. And that is the reason why this ministerial conference has to be postponed, right? So the global South is not able to access the vaccines. And that creates a significant issue in terms of the, at least one of the barriers why this is not happening is the trade-related intellectual property aspect, the TRIPS agreement, which is again part of the WTO setup. So the vaccine inequity provides a very live example of this imbalance that we have created in this world, whether under WTO or under investment regimes that we have. And I think we would not like to repeat this imbalance when we are trying to create this investment facilitation regime under WTO, in my view. The other difficulty that I see is incoherence. Of course, there are connections between trade and investment, something we cannot deny. But can we create an isolated compartment of trade and investment which has no correlation with human rights, labor rights, environmental rights, and climate change considerations? It will be unfortunate if we create those siloed approaches in negotiating investment facilitation. I think that is a serious issue in my view. The other difficulty is irresponsibility. If there are disputes, which are inevitable, whenever we have trade agreements or investment agreements, the disputes amongst parties are inevitable. Now, how do we resolve those disputes and who can bring those complaints? Now, if you look at WTO system, which is also facing some challenges in recent years, but ultimately the states are bringing those claims. But in many cases, states are bringing those claims to protect the interest of multinationals. But there are other actors who may be impacted by trade and investment policies. These could be communities, these could be indigenous peoples. Who will protect their rights? Who will bring disputes on their behalf? That is another question, which I would say the question about irresponsibility and responsibility of these actors that is quite relevant. So in the context of this, what suggestions, what considerations should be kept in mind going forward when WTO is going to discuss those particular issues? And here I would like to place 4 issues for consideration. My first suggestion is that states need to consider investment for what and investment for whom. Investment attraction should not be the end goal. Investment is merely a means. It is not the end. States should have flexibility in terms of which sectors they want to have an investment, because attracting investment may bring benefit to certain sections of society, but it may also disadvantage other sections. Let me give one concrete example. If a state opens investment in the supermarkets, let us say hypothetically, that is going to create a lot of jobs and opportunities for certain sections of society, but those supermarkets may also displace small vegetable sellers. Who will take care of that? Should states have those considerations and flexibility to decide which sectors they want to open up and to what extent? I think that is the key question that each state at different stage of development may have to consider. Whose benefit are we talking about? Are we talking about the benefit of investment for the top 10% in society? Or are we talking about the sustainable development goals, leaving no one behind? These are the key questions that states should be considering because there's a plenty of evidence to indicate that attracting investment is not a panacea. You need to get quality investment and you need to control it well to ensure that everyone benefits. That is my first point. The second point is we need to develop a holistic and coherent approach of investment facilitation. Whether this is part of WTO, this is outside WTO, does not really matter in my view. What is crucial is that states must not adopt a siloed approach. We cannot ignore that there are hard human rights obligations on states. We cannot ignore that the trade and investment regimes have significant implications for climate change. We cannot ignore that the trade and investment agreements have significant impact for marginalized communities like indigenous communities. And as we push for more renewable energy, that means more mining, it is also going to impact those communities more, because most of these natural resources could be in forests or could be in where those indigenous communities are living for centuries, if not more than that. And I think that is where it is crucial that states don't forget their obligation, their duty to regulate effectively both investment and investors. Defining what is protected as investment narrowly, not giving wide protection under the most favored nations clauses is absolutely crucial. Investors need only legitimate minimum protection, which is needed for any investor, but not more than that. And I think this is striking this balance. Having this proportional protection is absolutely vital. The third issue that I would like to highlight is human rights obligations of investors. Under international soft standards, UN guiding principles on business and human rights, the OECD guidelines for multinational enterprises, the ILO tripartite declaration, as well as emerging hard obligations, because we have mandatory human rights due diligence legislation, at least in 5 countries in Europe now: Germany, Switzerland, France, Norway, and the Netherlands. And European Commission is considering to have something for the entire Europe. So we see that there are significant jurisprudence of soft standards and the hard standards where businesses, which will include investors, they are expected to manage the adverse impact of their investment. So even if WTO facilitates this regime and there is a consensus and this regime is put in place, this cannot operate in isolation. Investors would have to respect their human rights obligations flowing from non-WTO regime. And that would mean that these obligations cannot be framed within WTO merely soft standards or merely corporate social responsibility standards. If that happens, that will create a further imbalance and will be counterproductive in the long run. And there is a concrete evidence that it proves counterproductive, as we have plenty of evidence coming from bilateral investment agreements. That is how it is proving problematic. My last point, and I will stop with that, is dispute resolution. How do we resolve disputes in a manner, in a system which is fair to all? And the difficulty that we see is that if we have a system which is similar to ISDS, which is Investor State Dispute Settlement System, that system is favoring investors and it does not provide opportunities to settle disputes, which is in a consistent manner. It does not give enough protection to the environmental issues, human rights considerations, or public policy considerations, let us say public health. And this is highly problematic. It also kind of gave what I will call privileged justice. So investors have a fast track system to get justice if they have any grievances, but affected communities lag behind and they don't have those opportunities. So it will be very crucial that disputes are inevitable. And if the disputes are inevitable, we create a system of dispute resolution whether this is part of WTO or outside, that allows all parties to address their legitimate grievances on the equal footing. I will stop with that, and I look forward to listening to other panelists as well as having this conversation. Thank you very much.
Thank you very much, Professor Surya, for your remarks, very important elements that we need to consider. We have Professor Correa here. He has overcome the first challenge to these virtual meetings. Professor Correa, you have the floor.
Well, thank you very much, Fernando. I'm very sorry I had some difficulties to get the connection, but I think it was great to have the first presentation by Professor Deva. I appreciate very much the comments and observations he has made. So I wanted to make a reference to the evolution of the framework on investment, and also make a reference to different concepts of regulation of investment as opposed to promotion, protection, and facilitation of investment. As we know, it was already mentioned by Professor Deva, most countries in the world try to attract foreign direct investment. And then you find that there are many countries in which there are agencies for promotion of investment. In fact, an UNCTAD report published in 2017 identified that 80% of the new measures adopted in relation to investment between 2010 and 2016 related to the promotion of investment. For some, promotion of investment does include facilitation. For others, promotion must be distinguished from facilitation. Promotion would refer essentially to marketing of a country or region to attract investors. And facilitation will start when there is an expression of interest in a particular country, and then a pre-establishment phase starts with some initiatives in order to actually do an investment in particular country. This distinction may be subtle, but I think is quite useful in order to examine the situation and to develop an international regime on the matter. And in the case of facilitation, clearly, as it is stated already in the in the investment framework, which is being negotiated in WTO, it does not cover only the initial phase of an investment, but also the expansion, the operation, and so on and so forth of an investment already made. But coming back to the evolution, it's interesting that, although as I mentioned today, most countries are looking for attractive foreign investment, this was not always the case. In particular, perhaps the first approach that was taken was more in terms of regulating foreign direct investment and ensuring that that investment will be in line with the national objectives. And perhaps one of the first countries to do this was Japan in the process of industrialization, the post-Second World War. And Japan had a very strict system to screen foreign direct investment. They wanted in particular to ensure that this investment will bring in technology and they will not create control over the economy. And then in the 90s, for instance, the participation for investors in Japanese economy was very small. About 1% of the economic activity was under control of foreign investors. This changed in the 90s, in the 80s and 90s, where Japan opened up their borders to foreign direct investment. Another good example is South Korea. South Korea, as you know, had a very rapid industrialization process and a very important technological catching up, but South Korea adopted the same approach. They were not encouraging foreign direct investment as such. They were just looking for creating local capacity under national controls, and then also use foreign direct investment strategically, again, until the 90s, in order to promote national development on the basis of champions. We know now some of the very strong Korean companies that have operation at the international level. So that's another interesting model. This model, in fact, influenced, in particular, the Japanese model influenced many developing countries in the 70s, in particular in Latin America. Most Latin American countries adopted laws for the regulation of foreign investment, under which there was a process of assessment and approval of this investment. One very well-known decision was taken by the Andean Group, Decision 24, which was inspired, in fact, by a Greek economist, Valentino Constantino Vaissos, sorry. And this was adopted in 1976, and many countries follow this approach in the sense of regulating foreign investment in order to ensure that there was a linkage, a connection between such an investment and the national objective. But this approach changed dramatically in the 90s. This was, to some extent, the result of the so-called Washington Consensus, liberalization policies that were implemented during that decade. Many of these laws, or most of these laws, were actually derogated, and then the concept was openness towards foreign investment. This is reflected, for instance, in the G20 guiding principles for global investment policy making, which were adopted in 2016, which recognize the government right to regulate investment for legitimate public purposes. But the clear objective of these guiding principles is towards an open global policy environment. This is preconized. This has also been preconized quite strongly by OECD in many documents and actions. But, and this is a big but, it's interesting that some of the major members of OECD, they still apply a regulatory approach to foreign direct investment. And this is particularly the case of the United States and the European Union.
You are muted, Professor. You are muted.
Okay. Sorry. So I was saying that the United States and European Union are applying a regulatory approach towards foreign direct investment. This was reported in some of UNCTAD documents. Let me just make reference to an agreement reached between the United States and the European Union in September this year in the context of the United States European Union Trade and Technology Council meeting in Pittsburgh. And then in accordance to this agreement, these two blocs have agreed to maintain investment screening by excluding investments based on environmental, social, and governance criteria for the purposes of national security in the United States and public order in the European Union. And both parties agreed on this principle. And of course, this concept of national security and public order is interpreted in a very broad manner in order to protect national industries, in order to do what is called techno-nationalist. That means to keep the preeminence of a particular country in some technological sectors. And this is very clear in the area of semiconductors, which is a battlefield in order to get preeminence in this area. And there are many examples. I will just mention a couple of examples of investments that were proposed by Chinese companies in the United States. One in relation to the acquisition of semiconductor producer Lattice. And this investment of 1.3 billion was rejected. And so there are many other cases in which what we see is that this openness that is predicated around the world is not actually practiced by major members of OECD. But then, while this process of regulation was taking place, in 1959, as you know, the first modern bilateral investment treaty was signed between Pakistan and Germany. And then many others, now thousands of agreements of this type have followed. And this evolved in a system of protection. So now the concept of protection comes in, a system of protection which is fragmented, which is based on loose standards, such as the standard of fair and equitable treatment or indirect expropriation, a system which does provide rights to investors, but not rights to the communities or to the states. It was already mentioned by Professor Siva, a system that provides for this investor-state dispute settlement, which is completely unbalanced and has led to huge compensation awards against many countries, including many developing countries. Although some reforms are taking place, some of them are not sufficient. For instance, there is some preambular language in some of the new generation, the so-called new generation BITs that refer to consistency with environment protection or sustainable development, but these are also in relation to business conduct, which should be consistent with protection of human rights. But this wording in general is preambular and these are not obligations subject to enforcement. And in this regard, I really recommend very much reading the last report of the UN Working Group on Businesses and Human Rights, and Professor Deva has led this work, in which there is a very important analysis on the subject and also very useful recommendation. I think this is a very important report to look at what the trends are and what kind of action should be taken. But then coming back to investment facilitation, I would like to stress that this concept has underpinned the Brazilian model of investment agreements. So as you know, Brazil did not enter into the conventional VITs. They developed a different approach, which is based on facilitation and cooperation in relation to investment. A very good example is the recent bilateral investment treaty between India and Brazil, which contains some of these elements and avoids many or most of the problematic elements in the conventional bilateral investment treaties, including the system of investor-state dispute settlement.
Facilitation. 1 minute more, Professor. 1 minute.
Okay, 1 minute more. Facilitation has also been promoted by UNCTAD, also by OECD, in particular document 2018. So let me just finish with 3 final comments. The first one is that in 1995, there was a exercise launched by OECD in order to develop a multilateral agreement on investment. This was for protection. And this exercise failed. In particular, there was a lot of opposition by civil society, including, for instance, Third World Network. But this failed because the participants in the OECD were not able to agree in particular about the sectors that would be exempted from the system. So that was a complete failure in terms of developing international law on investment. The second comment is that in the context of WTO, there are already disciplines that relate to investment. These are contained in the TRIMS agreement. TRIMS agreement is, in my view, one of the outcomes of the URA run, which has had negative impact, significant negative impact on the capacity of developing countries to neutralize, in particular because of the prohibition of local content measures, local content performances. And if there is a reform of WTO, in my view, there should be a look at this agreement. In fact, Article 9 of the agreement provided for the review of the text, which never took place. And I think that this should be looked at and changes should be introduced. And then the final comment relates very much aligned with what Professor Deva has mentioned, is that if there are new disciplines on facilitation of investment, they should avoid certainly to create market access rights. They should avoid to create pre-established rights. So the right to establish in a country if there is a policy in the country that is not allowing for that. So countries should retain the right to decide on which investments are possible, which investments are aligned with development objectives. As it was mentioned, it is not just the objective to get investment, but quality investment, sustainable investment. This is a word in use now in the investment facilitation text in WTO. And again, also I agree with the concept that any such regime should also create obligations for investors in terms of complying with the national laws, contributing to development objectives of the country in which the investment is made, and respecting human rights. Well, thank you very much. I'm sorry if I took a little longer, Fernando.
Thank you, Professor Correa, for your important remarks. Now we are going to move to our next speaker. Our next speaker is Ms. Luciana Giotto, a researcher in the UNSAM, CONICET, Argentina, and associated researcher at Transnational Institute. Luciana, you have the floor.
Thank you very much. Thanks for the invitation. It's really a pleasure to be here with people like Carlos Correa, who we have read for a long, long time now. We have been reading and learning from all your thoughts. Well, in my case, I wanted to approach this issue from a more maybe analytical approach. I would say, first of all, that because my predecessors have already spoken about this a lot, so I will try to go to some of the points that I want to bring up here. About investment facilitation, we have been reading this thing about for 4 years now. And what we have been learning is how it has been presented, how this discussion has been presented. It has been presented as maybe 3 main things. First of all, as a thing that is completely harmless. So one thing is that they say, well, we're talking about investment facilitation. So we are not talking about investor-state dispute settlements. We're not talking about protection. This will bring no problems to developing countries. This won't bring more claims against the countries. So this is just to facilitate investment, right? So in the first point is, when we discuss also with some of the people that are actually negotiating the agenda, they say, well, but this is like a small thing. This is something that will go completely, it's not important because it's just facilitation. It brings no more claims against the states. So that is the first point. The second point is that it seems that it will have no real impact on countries and no negative impacts on developing countries, because the third thing there is that you can't really measure, they say. When we see economists talking about this, they say, well, you cannot even measure how investment facilitation will actually come along. Where do we see that? For example, if you look at the impact assessment of the Mercosur European Union agreement made by the London School of Economics, you see that when they have to deal with the investment facilitation chapters, they say, well, this is just something that we cannot measure, and we don't expect any negative impacts of this agenda inside the agreement. So this is something that we're seeing that is presented as having no real impacts on the countries, which is something that we have to look with a lot of, with another perspective, let's say, because the truth is that if we look at the last 10 years of negotiations in WTO and in the free trade agreements, we will see that facilitation, the term facilitation, is something that has arrived, and it will stay for a long time. Where do we see that? Well, in WTO, we have trade facilitation, which is like the main big agreement, a multilateral agreement that was reached in the last 10 years. And then we have now investment facilitation, where we don't see that only in WTO discussion, but we see that also inside the free trade agreements that have been discussed in the past, let's say, 7 or 8 years. For example, the mega regionals, these big agreements like the Trans-Pacific Partnership, where we see a chapter, a very long chapter of more than 20 pages long, of regulatory coherence. So we're seeing that there is a whole approach that is being made regarding facilitating investment and trade. And so this is something that goes even beyond protection, because it's something that has come to stay for countries, and it's a new pressure made on regulatory capacity of countries all over the world, not only in the developing countries, but also it's a way of making a new path of discipline for regulatory issues all over the world. What's the base for this? Well, the base is the idea of that bureaucratic delays pose a burden for the free movement of capital and goods. So the thing is that what we are seeing under attack right now is the capacity of countries to actually make new regulations. So what we see now is like the final attack on regulatory capacity of countries. We also see another pressure being made. So not only WTO, this discussion, not only inside FTAs, but also with another concept that has come to stay, it seems, because we are seeing it everywhere, which is the concept of good regulatory practices made by the OECD. So we have like this approach of good practices everywhere. The thing is, how do we define a good practice of regulation? What would be a good practice, and what a bad practice would be? Who can say what is a good or a bad practice in regulation affairs? So what we see there is that the OECD has made a huge pressure also on countries, especially to advance in this idea of good regulatory practices. And we see this concept now being used for example, things that have to do with mining, good mining practices, good fishing practices, good cropping practices. You see this concept of good practices everywhere. And this idea is actually, the whole idea is to make the process for capitals quicker, faster, easier, with less bureaucratic burden, with less, with less regulations. So this is a trend that we are seeing, and it's something that should be addressed. So not only inside the investment facilitation debate, inside WTO, but also inside all of these agreements, like I was saying, the TPP, but also the new agreements that are being discussed. I said something about the example of the Mercosur-EU agreement. In the Mercosur-EU agreement, we have a package of 4 chapters that relate to regulatory burdens, this idea of making regulations easier and softer for capitals to move around. Of course, the question is, how do we measure that? How do we measure the impacts of that? And we, as from the academia, from the civil society, it's very important that we bring about this discussion on the idea that it's not something innocuous, it's not something that it's irrelevant, it's not something that is positive per se, it's not something that it will bring new perspectives to regulations for governments, but it will bring more, on the contrary, it will bring more, let's say, shields and for the capacity of regulation regarding human rights and sustainability in general. So actually, all this discussion of investment facilitation and this idea of good regulatory practices that the OECD is pushing for goes completely against the idea of regulatory policy space or regulatory space that the United Nations Conference on Trade and Development, the UNCTAD, the UNCTAD, has been developing. This idea of rediscussing the investment protection system in order to guarantee the regulatory space. This is something that the UNCTAD has been pushing for the past maybe 10 years, or yes, 80 years actually. And we are seeing that the discussion is moving forward on the need of reforming the system, on the need of countries to renegotiate their existing bids, their bilateral investment treaties, on guaranteeing new spaces for policy regarding human rights, labor rights, and sustainability. What we're seeing is that investment facilitation agenda goes on the other, to the other side, and actually is pushing against the possibility of renegotiating the existing bilateral investment treaties. So this poses a very good and important question, that is, where is the whole system of protection going on the one hand, and what will the relationship with investment facilitation go? And the last point that I wanted to bring in order to keep up with the time that I was told that I had to use, I would say that we have to see very strongly and follow very strongly the role of China pushing for this investment facilitation agenda. Why? Because what we see is that, for example, the whole Belt and Road Initiative relies not on investment protection, but on investment facilitation. And actually, we have seen China being an important actor in the investment facilitation and also in the trade facilitation agenda in WTO and the agreement that we have had for a couple of years now. So we have to see that maybe this new movement, this new moment of capitalism is requiring not only investment protection, which we already have a lot of investment protection because of the enormous amount of bids that have been signed for the past 30
1 minute, Luciana, please.
Yes, thank you. I'm finishing. And but on the other hand, what we have now is this agenda of now what we have in the center is the regulatory capacity of states to actually pose new questions regarding the protection of rights in a context of economic crisis and in a context where all the countries are desperate to bring investment. We see that, for example, that reality in Latin American countries, where the need for foreign investment is huge. So as my conclusion is that we cannot think that this agenda of investment facilitation is harmless. It will have impacts on regulations, and we have to find a way to measure those impacts in the short term in order to make a good political discussion about this new agenda. Thank you.
Thank you very much, Luciana. We are going to have a Q&A session, so perhaps you can expand more your ideas in that section. So our next speaker is Ms. Bahini Naidu. She's the Program Coordinator of Trade for Development Program at South Center. Bahini, you have the floor.
Thank you. Thank you so much, Fernando, and thank you to the panelists and to IISD for this platform. In the interest of time, I'll just focus my presentation on two key areas. And just to first initially preface my comments by saying that when it comes to investment, it's extremely important that developing countries retain the policy space to apply conditions and performance requirements to foreign investors in order to ensure that the host countries can actually benefit from this investment. And upon reflection of the text on investment facilitation, there will certainly be constraints to the policy space of signatory member states. And the primary concern would, of course, be how this will impact developing countries through some of the more generic obligations being established in the text and general principles for authorization procedures, which might be problematic. Now, the text also sets principles for authorization procedures in terms of requiring that each member shall ensure that authorization procedures it adopts or maintains do not unduly complicate or delay investment activities, or you shall ensure that all measures of general application within the scope of this agreement are administered in a reasonable, objective, and impartial manner. Now, the scope regarding measures of general application is extremely broad and as well as very unclear. And so for developing countries, they should be able to maintain their right to screen investors. And while they may have this right, our preliminary assessment has been that the criteria is still too vague. And developing countries should therefore be able to ensure maximum benefits and policy space vis-a-vis investments. Another issue that I wanted to raise is on the right to regulate investment. And here I should point out that there are many complementarities that can be seen between what is proposed in the IF text, as well as the Agreement on Services Domestic Regulation, which was announced just yesterday in the WTO. For example, there's provisions on transparency and on authorization procedures, which mirror those of the reference paper on domestic regulation. And in fact, they go beyond on it. And this would make investment facilitation an agreement with a particularly heavy implementation burden, especially for developing countries, through provisions that require each member to publish at the latest by the time of their entry into force international agreements affecting investment to which it is a signatory party. And the question then would be whether this includes agreements with companies. And if so, WTO members do not have the option to publish such agreements. So there's a big question mark around this. There's also other provisions regarding the publication in advance of laws and regulations of general application in relation to matters within the scope of the agreement. In domestic regulation, however, it limits the rule to this section in the DOMREG principles. Another thing could also be the introduction of language such as shall endeavor to explain the purpose and rationale of the law or regulation. But in domestic regulation, for example, the language that has been used is encouraged. So we're also seeing, some problematic or some burdensome requirements regarding commitments on single information portal, notifications to the WTO on the introduction of any new or any significant changes to existing laws or regulations of general application, as well as a single entry point in the case of multiple applications. And so while some may consider that such prior comment provisions provide the requisite transparency and perhaps a legitimate avenue for investors to be involved in policy-making areas that could impact upon their investment interests, as well as an opportunity for WTO members to interact with other members to provide their comments and views in relation to pending or draft regulations or laws. However, experience does show that when broadly applied, it could also provide private entities the opportunity to comment and promote their private interests, therefore placing the private interests at par with public interests in public policy making. Furthermore, I just wanted to point out that in terms of WTO jurisprudence, in the US gambling case, for example, members' regulatory sovereignty is an essential pillar of the progressive liberalization of trade and services. But the panel had ruled and said that this sovereignty ends when the rights of other members under the GATS are impaired. And just to conclude, I wanted to just mention one other case, which was in the WTO China raw materials case, where they said that the right to regulate and the relation to WTO rules basically came to the conclusion, or the panel said that a member has exercised its right to regulate by taking on its WTO obligations. So of course, there are a lot of constraints that we are seeing that would primarily fall on developing countries. And so perhaps there will be an important need to go back to revise some of the language that we're seeing in the text. There are still many problematic provisions that have been proposed. And in particular, and it's already been mentioned, the extremely broad scope, as well as the general obligations in the text, which have been reduced in terms of its so-called legal bindingness through, language such as to the extent practicable or shall endeavor. However, we would encourage that more attention be paid to the legal language and the legalese regarding some of the implications. I'll leave it at here, Fernando. Thank you.
Thank you, Bahini. Maybe we are going to have now the Q&A section, and I thank you all the panelists for these excellent presentations. So we have now 15 minutes for the section of questions and queries, and if somebody from the host, some attendee or any people, any person who is participating in this meeting want to participate, want to pose a question, you have to use, you can use the tap on reactions and raise your hand to have the floor, or you can also send your questions to the chat box, so we can address your questions here. Please try to be as precise and succinct as possible in order to have a rich discussion here, everybody to speak. So the floor is open for questions.
Fernando, I think there is a question on the chat for Luciana.
Yes, thank you, Professor. I didn't say it. Yes, Luciana, would you consider maintaining regulatory space is a good goal in itself, or only is as much it raises ambition and protection for the environment, human rights, and communities? Second, what would be a good benchmarks for you to assess whether an investment will spur sustainable development instead of bringing about further exploitation, inequalities, erosion of rights, etc.? How can investment pipelines be assessed? This is the question. Luciana, could you address it? You have the floor.
Yes, of course. Just some thoughts in a very short time. First of all, I think that we have to see and acknowledge that the pressure is huge. The pressure on states is enormous. The idea of the past 30 years has been that either you go down with regulations, you make your regulations less burdensome for capital, or you won't receive foreign direct investment. That has been like the main discourse of the past 30 years, and we have been hearing that in the 90s, and we still hear that now. So the idea is that if you want some investments, you have to lower your regulations. So the thing is that how, the question, I would answer that question with another question, is how can states actually have better regulations when the pressure to facilitate investment is in the whole investment cycle. For example, in this discussion in particular, we see, for example, I was rereading the Easter text of the investment facilitation agenda, and it says facilitation of admission, establishment, acquisition, expansion, management, conduct, and operation. So you have to facilitate the whole cycle of investment. Facilitate means that no further regulation can be addressed in those periods of investment. So it has to be very simple for capitals to arrive, operate, and leave when they want. So no further burdens there. So if we want to see how to assess that and how we can change that, we should probably see the examples, and we have to see state by state. We have to see the examples of the countries that in the past 15 years try to have different national development plans, like Bolivia or Ecuador, for example. The examples of them are very interesting because in their constitutions, they have another way of treating nature, another way of dealing with human rights, broadening the concept of human rights, and for communities and indigenous groups as well. But what we see is that investors already have this framework that actually gives them the possibility not only to have facilitation, but only they have the protection of all this framework that we see that has been established in the 90s. So the thing is that I go again to the beginning. The pressure is really, really tough. The pressure is going very, very, very strongly against regulations. And we will need actually to see if states in the national or local arena are actually able to have these better constitutions, better internal laws that will actually enter they will start fighting the protection, the investment protection agenda and the free trade agreements. And there we will have to see how politically this is managed. This is not a legal question. This is a political question. How we actually manage all these internal processes, political processes in each country that actually make this collision, they collide with the agenda, the general framework of investment facilitation and investment protection in particular. So there we'll have to see country by country, and this is something that is new. It's a new trend, but what I wanted to bring is this idea that this trend seems to have come to stay, and this is something that is dangerous. We have to deal with it, not as if it were something innocuous or something that is just facilitation. It's huge. It's a huge agenda that is coming in WTO, in the FTAs, and with the example that was given before, Brazil, that has no FTAs and no BIDs, now has facilitation of investment. But again, it's not innocuous. We have to see the impacts, and we have to see how regulations actually adapt, national regulations adapt to this new global agenda. So we have to be very careful about how we deal with this. Thank you.
Thank you, Luciana. Ignacio, who has posed the question already, thank you. Apparently, the question has been well responded. So somebody has another question, please use the chat box or raise your hands. Yes, Professor Surya.
I don't have a question, but I just want to add my reaction to the question which Luciana just answered in terms of the pressure. I think the pressure is very significant, but the key question for us should be how can developing countries counter this pressure? If not completely, what strategies can we use? And I will mention a couple of ideas here for the consideration. One is that we need to challenge the narratives which have been pushed consistently, including by international organizations. Let us say the narrative of that unless states open up their markets, they will never get the investment. Or unless they have significant protection for investors, there will not be any investment. But if you look at the empirical evidence, between bilateral investment agreements and the attraction of investment, there is no conclusive evidence that the bilateral investment agreements facilitate investment. So that is, so if we policymakers, academics, think tanks, organizations like South Center, even OECD, I mean, so the question is, can we present objective evidence-based research to showcase that would help in countering those narratives, which sometimes are getting reinforced with less substance. That's my first point. The second point is that it is absolutely critical for developing countries, or at least like-minded countries in the global South, to take collective positions. Because the real difficulty lies in those situations where the investors or certain countries in the global North push an agenda and try to push countries one by one. So if there could be some baseline agreements that, okay, we want investment, but these are the things we would expect and all investors to follow, I think that may help in countering some of this pressure, which is definitely very, very real. Thank you.
Thank you, Professor Surya. Luciana, you have another question, apparently some follow-up question. You explained that we should see the impact and assess each national regulations for each state, but is it possible to also assess by group of countries? I mean, would that an assessment larger scale such as EU1 be a solution? Such group of countries would also offer us sufficient legally binding agreements? Please, Luciana, help us.
Oh, yes, the idea of the EU and the group of countries is really interesting. In fact, that's why I said it very quickly maybe, but the idea is that this pressure is being not only posed on developing countries, but of course it's also being posed on all the countries, even the most industrialized ones. We see that, for example, with the with the precautionary principle, of the EU. I mean, countries like such as Brazil and Argentina have been making a very strong pressure on the principle that the EU has. And actually, I say all the time that I would like to have that principle going on in Argentina or the Mercosur countries, instead of knowing that my country makes pressure to actually stop having that protection on European consumers, right? So that is something that we have to understand, that is global. And the thing is, that's why the role of transnational corporations is very important to be understood in that process. Every time that a new initiative is trying to be developed, like for example, the Binding Treaty Initiative inside the UN, we see the pressure of the most industrialized countries that are actually the ones that also suffer of this pressure, but they go to the UN and say, we don't want the Binding Treaty. Why? Because in my country, I have the big transnational corporations that are actually the ones that are taking the most advantage of the whole system, going abroad and making huge investments abroad and huge gains of capital, right? So this is something that, of course, needs to be addressed in group. And we should be trying to see how, for example, we have this pressure on regions. That's why we can think of, for example, in my case, I work especially in Latin America. And we see that the extractivism that is going on, like a new trend, but it's actually is a historical trend of being able to sell only raw materials and energy to the world. What we see is that this whole system is doing a much stronger pressure now with all the bids going on, the FTAs, and now the investment facilitation. Countries such as Argentina have said, and this is one of the countries that I heard from the negotiators saying, well, but this is not important. This is, I mean, we're the country that has been sued the most in ICSID, for example, right? By claims by investors through ISDS, and they say facilitation is like nothing for us. And it's like, no, it is something, because if you want to have good practices inside the country where you can see that, for example, and today is a national struggle day against agrotoxics. And if you want to put a halt to agrotoxics, you need, such as glyphosate, for example, you need yes or yes better regulations that this investment facilitation agenda will not allow. So we're inside a circle that is rather critical, and we have to see the ways to fight at the same time this agenda in the global scale, but also create the new teams for working these agendas inside the national level. Otherwise, it will be impossible, because the trade ministries or the foreign affairs ministries are all for this agenda. They say, well, it's innocuous. It makes nothing. It has no effect on us. So we have to create these bonds of the national and international agenda also. I will leave it there, otherwise I speak too much. Sorry.
Thank you, Luciana. We have time for one more question. A question has been raised for Bahini. Currently, not all member states of the WTO have supported the structured discussions on investment facilitation. This has led to the possibility of reaching a plurilateral agreement. What would be the nature of the IEF agreement as a plurilateral agreement in comparison to WTO disciplines adopted in WTO? Bahini, could you give us your thoughts on it? Bahini?
Yes, sorry about that. I was just unmuting myself. Yes, so one of the challenges is whether this agreement can find a place structurally in the WTO. And if so, it will be done through a plurilateral agreement, but it can only be done if there is consensus in accordance with being an Annex 4 agreement. So there's a number of challenges regarding this, particularly whether the dispute settlement understanding would be applicable. And in terms of this, I think I should just point out that consensus will be needed, firstly, to add a new Annex 4 agreement. So if this IF agreement does get through, one, you will need to have consensus to get it to apply to for it to be multilateralized. And the second step would also be that consensus will be needed to add the agreement to Appendix 1 of the dispute settlement understanding if it is to be applied to dispute settlement. And I think one of the challenges that we're seeing around this is there's not been much of a conversation amongst the signatory members regarding the applicability to the DSU, but also, you know, they're still struggling from a legal perspective in terms of how they intend to get this agreement into the WTO. And there's a very interesting and important submission that has been tabled by a few countries, namely India, South Africa, and Namibia, on the implications of putting in a proposal. And I think we can try and just get it onto this chat so that other colleagues can have access to it. But just to also conclude to say that notwithstanding, you know, all the legal issues, where the text is at the moment, there's definitely a range of obligations that we will need to decipher, and the implications will need to be further assessed. And in terms of the negotiations, there is some comfort in the sense that it has not yet been closed, and that there are many things that still remain unsettled in terms of scope, definition, MFN, etc. And finally, I did put a link in the chat box to introduce colleagues to one of the policy briefs published by the South Center by my colleague, Peter Lunenberg, which basically highlights the possible implications of the adoption of the MFN clause in such a framework, and what the implications will be, as well as the obligations of other bilateral or regional treaties into this IF text. Thank you, Fernando.
Thank you, Bahini. In order to stick to the time that was assigned to the South Center for this meeting, we are going to pass to the last part of this session, that is concluding remarks from our distinguished panelists. I would like to start with Professor Surya. Professor Surya, you have 3 minutes for concluding remarks. Please, you have the floor.
Thank you very much, Fernando. And it was a very useful discussion with these different perspectives. In my concluding remarks, I would like to just highlight two elements. One is that whether this is this kind of investment facilitation is negotiated within the parameters of WTO or this happens outside, it is absolutely critical that we focus on the obligations of investors. Otherwise, and I think many states, I think Luciana was talking about this, that the treaty process is being opposed by some of these countries where these multinational investors are based. At the same time, I think we should be aware of the changing ground realities. We have now multinationals coming out of developing countries in the global south as well. And they are significant players in terms of investment. So it's not merely, so it's not 1980s or 1990s situation where more than 80% of these multinationals were based in the US, Europe, or Japan. I think that dynamic had changed significantly because we have big multinationals from the global south investing south-south as well as south to north. At the same time, it is important to use the global consensus, at least, on the soft standards in the form of whether these are UN guiding principles or the OECD guidelines. So those soft standards are accepted by all countries. And I think that should be a good starting point to ensure that whenever we talk about investment facilitation, I think Professor Correa made a crucial distinction between promotion, facilitation, regulation, protection of investment, but it does not really matter in my view. At all of these stages, investors have to behave in a responsible manner. They cannot ignore human rights. They cannot indulge in bribery. They cannot do unfair practices. And they cannot ignore, let us say, the principles of FPIC, for instance, right? So how do we embed these wider principles of investors' responsibilities and I would say obligations, and how do we create a mechanism under which these investors' obligations could be enforced? Because it will not be enough to have merely obligations. We would need to create a system under which these obligations could be enforced against the investors. And I think that would be my final point. Thank you.
Thank you very much, Professor Surya, for your participation and for your final remark. Luciana, could you give us your concluding remarks? 2 minutes, 3 minutes?
Yes, just 2 or 3 things because I already spoke too much. But I think that, yeah, in order to think about developing countries' interests, I would suggest, I mean, if I had the possibility, I would suggest that countries still have to be focused on investment protection agenda. I mean, the main focus still has to remain pushing for having a reform, a real open and democratic reform of the investment protection agenda of the BITs and of all the investment protection chapters that are included in FTAs. Because if we, as developing countries, if we get involved in the facilitation agenda that brings all the issues that have been spoken about, but without revisiting all the protection agenda, this will be huge chaos. Because we are not only protecting, but facilitating and keep pushing down on regulations in every country. And this will have huge impacts in the future, because every time we want to have a new regulation, for example, on sustainability, on energy transition, all this system, on all these commitments that countries have made will come and will be set upon our heads. So I think that we still need, and we were discussing here in the chat, we still need some countries that are the leading parts in this discussion and show all the contradiction of these agendas, as we had some years ago with countries like Bolivia or South Africa itself or India itself some years ago, we need some countries that show the impacts of this agenda and the need for reform. That's what I would say.
Thank you, Luciana, for your participation today. Our next final concluding remarks is from Bahini. Bahini, could you give us your concluding remarks?
Yes, thank you very much. Just finally, I think I would want to say that investment in and of itself is not a trade issue per se. And, you know, all my fellow panelists have been emphasizing this throughout the day or throughout the session. And just to point out that the trade related aspects have already been treated in the WTO through TRIMS, GATS Mode 3. And so it would be best for any binding investment rules to be undertaken or that there is much more attention paid to the forum in which these rules will be undertaken. And there's big question marks about whether there is a role for the WTO in this whole discussion regarding the mandate. And the issue regarding the Marrakesh Agreement, establishing the WTO in terms of members' trade relations, in particular, you know, Article 3.2 and Article 2.1 of the Marrakesh Agreement does raise a lot of question marks surrounding, you know, how we get to treat this agreement in the future. And finally, just to conclude by saying that while the current proposals on IF purportedly do not have market access implications, I think that to some extent, you know, some of the kinds of disciplines suggested in terms of screening criteria, for example, will have market access implications. And therefore, we should not be blindsided by the so-called facilitation agenda, and developing countries should maintain their rights to screen investors according to criteria of their own, as well as retaining their policy space and the very important regulatory sovereignty. Thank you.
Thank you, Bahini. Finally, Professor Carlos Correa, I would like to invite you for the concluding final remarks of this session.
Okay, let me make 4 comments. The first one is that neither facilitation or protection of investment is a magic tool. So this will not bring about investment. Investment is made taking into account economic development, policies applied in the country, prospects of economic growth. So this is not magic tool. Today, 110 countries are participating in this exercise of developing the investment facilitation framework. So maybe some of these countries may expect this framework to bring more investment to the home countries. This will not magically happen, as it was mentioned also by Professor Diva. So there is no evidence even that the BITs actually increase the level of foreign direct investment. So I think that this is an important concept to recall. Secondly is regarding the wording of the IF proposal. I think we need to stick to a literal interpretation as mandated by the Vienna Convention on the Law of the Treaties. So I would not really favor expansive interpretations of the wording or the provisions which are proposed there. For instance, it has been mentioned that this agreement should not be seen as limiting the regulatory capacity of the countries. I think this is very important to preserve. In fact, the G20 principles I did mention, as I did mention as well, did make it clear that the governments retain the capacity to regulate for public purposes. So I think this shouldn't be the reading. If there is an agreement on this subject, it should not in any manner limit that capacity. And in fact, it's interesting that, as I mentioned, the United States and the European Union are perhaps today the strongest regulators in relation to foreign direct investment, not developing countries. The third comment relates to there is also a need to avoid discrimination against investments coming from developing countries. So as was mentioned, also some developing countries have the capacity to invest both in developed and developing countries. And then we should also look at a system that does not discriminate against investment coming from developing countries. And then fourthly, I would like also to stress that there is already in WTO an agreement on which relates to investment, the TRIMS agreement. I think it would be very important to review that agreement as provided for in Article 9. It has not been done. and it really limits a lot the policy space, in particular for industrial policies. And then if there is discussion on investment in WTO, as it has been the case in the past in the Doha round when this agreement was developed, I think we should also expand the discussion and look at the review of the agreement, and in order to allow developing countries, at least developed countries, to use the tool of local content and other performance requirements. Thank you.
Thank you very much. Thank you very much, Professor Correa. We arrived to the limits of our time. So I would like to thank you all, the panelists, for their presentations, very interesting and insightful comments, and also to express my appreciation to all the participants to this meeting. The virtual meeting has concluded. Thank you very much.
Bye-bye.
Bye-bye.
Thank you. Bye-bye.